Hi everyone, I'm immigration lawyer John Khosravi. Thank you again for joining us. Today is November 10th, Wednesday, 6 p.m. Pacific time. We're across the world recording this. In the US, we've had daylight savings, so things have adjusted an hour. So for those of you watching internationally, this may have messed up your timelines, but hopefully catch this. If not, you can catch the recording of this, which will be on YouTube and Facebook and various places. Now, before we start, a couple of notes. One is we do give our regular raffle free consultation giveaway, 15-minute video consultations. We give away 3 of them once every 10 minutes. So if you're interested in that while you're watching, just click like, subscribe, and write consultation where you're watching this, so that my assistant Kayla will announce a winner, or tell me to announce a person that won every 10 minutes or so. So we'll have 3 of those. Also, if you're interested in a marriage case, a fiance case, or learning about the process for U.S. immigration, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. It's the best resource out there for free that really breaks down everything you need to know when you're getting started this process. So before you talk with an immigration attorney, you can know what's going on and you can evaluate them based on their knowledge of the situation, because you have the knowledge. So the things we're going to talk about right now is general education only, not meant for individual legal guidance. But people are tuning in right now. We're going to have some questions pop up. So let's get it started. All right, so it's been crazy as always in U.S. immigration. A lot of things are not happening. Some things are happening. With regard to news, the processing times overseas are all over the place. Some embassies are operating. We have airplanes coming to the United States from abroad now because the travel ban has somewhat been lifted, in a sense that there are countries where you could not leave and come to the United States unless you fall within a very small exception. But now it's open. If you have a COVID vaccine that it matches the requirements, it's accepted version of it, then you could do that. Now, I have a separate show I started with my associate Anya Sergieva where we went into detail on what the vaccine requirement is. So check that out. It's called Immigration Talk. It's on our YouTube channel, of JQK Law Firm's YouTube channel. So we got a lot more detail there on that, but that's a positive. How much time does USCIS take to approve an I-360 as a religious worker at California Service Center? Well, there is no timelines in any sense when you're dealing with USCIS. There's general stuff for some cases that are more typical that you can see, but not necessarily. So you can go to uscis.gov. And they have general processing times that they put over there, but how reliable those are, it's all over the place. So that's why I don't have answers for these timeline questions. Hopefully it's sooner rather than later, but we're seeing a lot of delays. Now, I don't handle 360s, but I've heard they're taking much longer, even a year longer than usual, from colleagues who do handle those cases. That's why it's really hard to say. You just want to make sure you're maintaining proper status, not violating, and take care of other things while your case is pending. So that's the situation abroad in the United States. It's all over the place. I'm a green card holder, just got to the United States. Congrats. What's the fastest way to get my unmarried over 21-year-old son to the United States? Well, fastest way, I mean, if your son's a star athlete or a great musician or something like that, they get an extraordinary ability visa. But I don't know if that's the case. If your unmarried son is over 21, you probably will have to file a family-based case. There may be exceptions to your case. You might have a different kind of situation going on. Like I said, that your son might be a great athlete or something like that. But barring that, you have to file an F2B I-130, which is the adult, single, unmarried child of a green card holder. Last I checked, I don't know, it's taking 6, 8, 7 years or something like that, depending on which country you're from. Check the visa bulletin, but the sooner you start, the better it is, unless your son falls in love with a U.S. citizen or a green card holder and wants to get married and come. That might be a faster way. So when you say what's the fastest way, there's 20, 30 different immigration programs the U.S. has. Some are faster than others. It really depends on the situation of the actual applicant to say which one's fastest, because they probably won't be able to apply for a lot of them. But if you're the basics based on information you told me, you being a green card holder, that's the option that exists there. Your son should have a private consultation with an attorney to see if something individual applies to them. But that's it. If you want to apply for them, it's going to take a couple of years. That time will fly, but they'll probably be in their late 20s by the time they come to the United States. But thank you for your question. Congratulations on getting the green card. Now, one thing you got to check is how you got your green card and if your child could have got it with you as followed to join. I'm guessing it probably couldn't if you don't have it. It doesn't have your green card. That's something to look into. I applied for the I-90 replacement green card. So I-90 is when your 10-year green card is expiring or expired. You file Form I-90 either online or by paper, and you get a new one. And Habib says, USCIS waived my biometrics. I have been almost 5 months waiting for approval. How long does it take to get the renewal? It takes between 2 or 3 months to 1 year or longer. So as I was talking about at the beginning of the show, there's no specific timelines for things. Hopefully it takes 3 to 6 months, but I've seen it take more than a year. So you just got to be patient. When you applied, you should have got an automatic extension for 1 year period of time. And that kind of tells you the fact that they give you a 1 year extension means they're expecting things to be delayed a lot. So that'll hold you over. So if you need to travel overseas, you have the extension notice and you have your expired green card. You take those together to be able to travel and to show proof of work. If 1 year passes and you still don't have your green card, we should contact them to see what's going on. But in the meantime, you can schedule what's called an info pass appointment. Very hard to get it nowadays, but you call them up and say, I need to go in person. I need proof of having a green card so I can travel or for employment, and then they can stamp your green card. Many times I think the regulations are for employment that even if your green card is expired, they're not necessarily supposed to ask you for proof, but I can't remember the exact rules. Hasn't come up recently, so I don't recall. But you know, it'll hold you over, and then you gotta just keep working at it, unfortunately, because these timelines are non-existent. But thank you for your question, Habib. Hashim asks, how long does it take to apply for a social security number through the embassy? Hashim, you know, you don't necessarily apply for a social security number through the embassy. If you've got a green card, you order it in the US. There are examples of cases where I have clients who are born in the United States, they're citizens, they leave the United States immediately, and they never get a social security number. All of a sudden they're 30 or 40 and they want to come back, or they have plans to come back to the United States, or more likely they would get married and want to get a green card for their spouse. Well, they need a social security number. Now, if you're overseas and going to apply for a social security card while abroad, that process is fraught with difficulty, easily going to take 8, 10 months, a year, hopefully not longer, but it could take it. So in those kind of cases, usually we ask clients that they fly into the United States and deal with the local office to be able to apply for their social security number. When they're in the local office, they'll ask them to show proof that we're consistently living overseas. So it's a hard requirement. I couldn't find it in the regulations because they kept asking my clients for it, but they still do. So you have to prove you've been living out of the United States consistently for 20, 30, 40 years. They're not as strict, depends on the officer you're going to get at the Social Security office. But again, when you ask, when you ask how long does it take to apply, I don't know enough about you, Hashim, to be able to answer that. I don't know which scenario you're in. So you really should contact an immigration attorney in private to talk that through. But thank you for your question. Irene Regulars, hi John, how are you? I'm doing good. Does USCIS immediately deny a marriage green card application and adjustment of status case if the U.S. citizen petitioner owes back taxes from previous year? No, it doesn't automatically deny it. If you owe back taxes, you got to find a joint sponsor because you don't make enough. Generally, having back taxes is an issue for citizenship because it goes to bad moral character. But if you're a citizen and you're applying for a spouse and you have back taxes, you have to talk about it. It's going to be listed in the affidavit of support. But that in itself, I haven't seen it be a problem. The issue is then you got to find a joint sponsor, which may be a little complicated finding a joint sponsor, but that's what you do. And hopefully you have a payment plan with the IRS to show you're going by the book. As long as you have some sort of payment plan and a joint sponsor, I wouldn't be worried about a denial. But I need to dive in more deep into your case to see what's going on. But that's not the worry I would have there, Irene. But thank you for your question. Good to see you again. Ari follows up, what if the petitioner has arranged a payment plan? Will it have a chance to be approved? Thank you. Well, the payment plan is just a payment plan. For the approval of your green card case, you have to have someone who makes enough money. Now, if you currently make enough money but have a payment plan, it's going to go into discretion. So it could be approved, but I would just strongly recommend having a joint sponsor in that case so they don't hassle you because they'll say, well, you're making money now, but you have a payment plan. They don't really I haven't seen information or guidance on that situation, so that's not something that I've seen, but I don't think it's that big a deal having a payment plan and owing back taxes, but to be safe, you know, a joint sponsor is strongly recommended. Hamza asks, good evening, sir. Can you provide information about humanitarian parole process for Afghanis, people from Afghanistan? You know, I don't handle humanitarian parole. Right now, the system, the USCIS part that handles humanitarian parole is just completely overwhelmed. But essentially, you just plead with them for I-131 and say, listen, please give humanitarian parole. But it's not a kind of case I handle and I have experience with, so I'd recommend consulting with another attorney that does to help you better than I can. But thank you for your question. I'm sorry you need that because it's unfortunate. The situation in Afghanistan and just needing humanitarian parole really usually comes with some, you know, desperate situations. 29 Super C asks, hi, Attorney Khosravi, the U.S. Embassy had a Facebook Live but didn't answer what documents and complete dates are doing the B3 category. Thanks, 29 Super C, like that's a shame. So The embassies, they say they do things on a first come, first served basis, and this USCIS too, but they kind of pick and choose these cases, and it's not clear when things will happen. So for those just tuning in, don't know this terminology mean, documentarily complete or qualified is when you're applying for a green card through the embassy process and you initially submit documents to the National Visa Center, the NVC for short, and they take a look at your documents and make sure they're at least in order before you go to the embassy interview. And when they review at the National Visa Center and they're satisfied, they say this is documentarily complete. That's a new terminology. Up till last month, they would call it documentarily qualified. So the idea is, well, if it's complete, they put it in order and they just start doing interviews. So 29 Super C asked them on a Facebook Live on what's going on, and they just didn't have an answer because I don't think they go by order, even though they say they do. I think they just pick it out and they don't share this information with us. So you had a live right there, you had them in front of you and they didn't answer you, and that's the case. They don't really give us this information. The U.S. Embassy in general, the State Department is very secretive and doesn't really give out information. They have some, stats and statistics on our website which are getting better, so not fully that bad, but when it comes to active operations, it's really hard to see what's going on and getting information that can help us. So that's the situation that we have. It's very frustrating. Alexander asked, hi, I received a receipt after 5 days of filing. I did 10 days later biometrics, well, it was all fast. And now my status case is being actively reviewed by USCIS. What's that mean? Thank you. We'll get this question a lot, and it means exactly what it says it means. They're actively reviewing your case. They can't just make a decision on a case immediately. They have to do research and background checks. So you just have to be patient for them to, continue working on your case to make a decision. And that's that. Nicole asked, my husband goes for citizenship exam November 23rd. Any tips so he isn't nervous? Well, I don't know your husband's case to see what's going on. I mean, he's got to be prepared for citizenship. You got to, know the civil questions. Hopefully his English is well enough to be answer questions, write a sentence. There's that aspect. But then we have to go to his immigration history to make sure there's no violations there. He never falsely claimed to be a citizen. He never been arrested. He never not paid taxes. There's all these sorts of things depending on how old he is. Did he sign up for the selective service draft? So there's a lot of pieces of information I'll need to know before I give any tips. But that's the general overview, and that's that. But maybe it's November 23rd, just have your husband schedule a practice interview consultation, a practice naturalization interview with an attorney, so you go through it once, so at least when he goes into the office, he's more prepared. Or if he's really nervous, just hire an attorney to come with you to the interview. It'll give you a better sense of self and confidence. It costs money, but if they're really nervous, that would be the way to go, just to kind of double check things. But hope for the best. Hopefully get citizenship soon and help your husband be a citizen before the end of the year. Congrats, Nicole. Anisha asks, I saw your video about the I-824. Did you get any response how long it takes to approve I-824? So the form I-824 has several uses, but the main one is when you have a petition approved with USCIS and you want to have the case transferred in some form or fashion for some reason to the embassy system, National Visa Center, Department of State. And so how long does it take? Sometimes it takes 3 months, sometimes it takes 15 months, sometimes it takes 6 months to get approved, but it doesn't get sent out. It just gets lost. And I was talking to a client the other day, a colleague, and they say they have to sue the USCIS a year and a half later because their I-240 is approved and they just wouldn't move it and they said we can't find it. So it's a terrible form, the I-240. Sometimes if you're, for example, doing an I-130 marriage-based and you accidentally marked adjustment of status, but you really wanted to do consular processing, it might be easier and simpler to just refile and do an I-130 instead. I'm about to do that for a client right now, somebody who's actually watched the videos. It came to me, they had, long story short, they need the case transferred for a marriage case from the US to the embassy, and they wanted to do the I-240, and I said, listen, the I-240 is inconsistent. It might take twice as long as an I-130. It might take half as much time. But redoing I-130 is more consistent as to the timetables. You've already had an approved I-130, so potentially we could tell them it's been approved and we marked the wrong box for adjustment instead of consular processing. So please just give us an expedite on this because this case is already approved. There's not extra work you have to do. We just made a mistake, and I-240 takes too long, it's too complicated, and so we want to prefer not doing that. But yeah, that's the inconsistency of the I-240. A lot of people don't file it, very little experience there, and just a lot of bad news when it comes to it. When you are filling out the form I-130, I mentioned earlier about a case where a person requested adjustment of status instead of consular processing, and sometimes people are doing adjustment of status, which is, they get married, file for the green card in the United States. While the case is pending, they're forced to leave the United States for various reasons, and all of a sudden, they start a case in the U.S., and they're not here, so and they can't come back to finish it because they didn't get advanced parole, for example, which is permission to come and go. So the cases here even gets approved, but they're overseas. USCIS will typically not automatically send it overseas. If you're lucky, they will, but most of the time they won't. Now, you could try writing letters to them, say, please send it overseas. May or may not work, probably won't. The official way to send it overseas is Form I-824, which is requesting that the USCIS move the case to the National Visa Center for consular processing, and it's unknown how long that's going to take. So it's going to be a while before we even know. So sometimes, as I said earlier, it takes 3-4 months for I-284 to be approved. Sometimes it takes over a year, and then once it's approved, sometimes it takes months for them to actually move it from USCIS to the National Visa Center. So in these cases, if possible, sometimes we just refile the case, whether it's an I-130 or if it's possible, because some I-130s could take years to be approved. But in a marriage to a U.S. citizen case or a green card holder case, for example, the I-130, maybe an I-140, this is kind of a costly way to do it and risky, but filing like an EB-1A, extraordinary ability, all over again to get the case sent overseas. It's a judgment call. You have to analyze, the good, the bad, and all that kind of stuff. But they definitely have made it a little bit difficult to deal with, and that's why, if you're gonna make a decision about I-284, you got to talk to the lawyer to see how your case looks and make sure it's worth it, because they're just so difficult. What is the difference between a courtesy copy of receipt and a physical notice? So, as a lawyer, when I submit a case to USCIS, and there may be different variations on this, but I think this is what you're meaning. My clients eventually will get a receipt or maybe an approval notice or whatever it is, and they'll usually get it on a thicker piece of paper, a different type of piece of paper that's addressed directly to them. But as an attorney, I get a courtesy copy of it as well as a secondary copy. And sometimes it's exactly the same as the client gets, and sometimes it says this is for the attorney, the client got the original, and it's just a backup. So the lawyer, for example, I know the receipt number that the case is moving forward. Sometimes the post office loses the document or the original notice that's being sent to the client, and so it's good for me as an attorney to get a backup, so at least we have it as proof. It has a case number there, and we can always use that if need be for certain scenarios. So that's what's happening with regards to these different receipt notice types. Now, I get a lot of contacts, people saying my I-797 came, and Form I-797 just means a communication from USCIS to you. It doesn't give me any information as an immigration lawyer as to what it is. That's why a lot of these websites too, help people do it themselves. They say, I got my NOA1, NOA2, all this kind of stuff. Immigration lawyers don't talk like that. We use much more simpler language. You get a receipt notice, I got my approval, I got my reminder to do the medical, I got an RFE. We don't use terminology NOA1, NOA2, CR1, CR2. We just say, 2-year green card, 10-year green card. It's one of those things, a lot of times lawyers use bigger words to make things sound more complicated, and it sounds bigger. But in this case of immigration law, lawyers usually just ease it up and simplify it and just use, hey, I got a receipt, oh, I got an approval notice, I got a denial notice, I got a notice of intent to deny, NOI there. So we just make it easy. I know that wasn't your question, but I just want to reference that because we get a lot of people mentioning this kind of stuff. Sam asks, hi, Mr. John, should I apply 3-year rule or 90 days before, and what documents should I submit with the N-400 based on marriage to U.S. citizens? So Sam, I can't give you individual advice because I don't know anything about your background for me able to guide you, and I'm not your attorney, so I just got to make that clear at the very beginning. But it depends. So when you're married to a U.S. citizen and you have a green card, you typically have to wait 5 years to file for citizenship if you have a green card. But if you're married and living with the U.S. citizen, you could file at a 3-year mark, and they allow you to file up to 90 days beforehand. So there's a website, USCIS. Just go to Google, type in USCIS Naturalization 90-day calculator, and put the 3-year mark from the date that you got your green card, and they'll tell you what 90 days is, so you see what window you have to file. Now, what you need to file, now every case is specific. Some people have arrest history, some people have all this other stuff. You may need additional stuff. But the basics for filing for citizenship based on marriage is, using N-400s, the basic application, include a copy of the front and back of your green card color copy and your marriage certificate. And you may want to, I don't always do this, but they want you to do this, but I don't always do it, but have evidence that you've been living together for the last 3 years. And so a lot of times we do 3 years of tax returns, 3 years of worth of lease agreements. They're not strict if it's obvious that you're living together, so that's that. Now, if you've had previous marriages, you might need divorce certificates for yourself or for your spouse to show those divorces were done. If you've been arrested before, there's arrest history kind of stuff that has to come into play. If you had to sign up for the selective service draft, you want to get that information that you signed up in time. If you're under the age of 26 when you got your green card, or you're in the United States in a status other than a non-immigrant visa. So it goes in a lot of stuff that I can't get into here because I don't know your unique case. But also, there's the physical presence requirement of how long you've been physically in the United States. So if you're filing for marriage-based, U.S. citizen marriage-based citizenship in 3 years, a year and a half that time you have to have been physically in the United States without long gaps in between. That makes it look like you had abandoned your status or you're not living here. That breaks what's called the continuous residency. So you want to be careful of that and not have done that. So again, I will need to review your travel history, how you got your green card, what's going on in your relationship now, how to prove you're in a relationship, your green card, divorce certificates, and that's the general idea to really solidify it, make it strong, and hopefully have it go by smoothly. Unfortunately, the timetables are kind of a mess, so it could be 3 weeks after you file, get your interview. It could be a year and a half. That's the timelines I've seen. Now, I have seen people get interviews in 3 weeks, not myself, one of my colleagues. Not typical, 3 months is more typical, but it really depends on your local field office. So local office you're going to, how long are they taking to schedule interviews? Now, I actually have an interview coming up for a client for citizenship. We filed it a year and a month ago. And the same day that I filed his citizenship a year and a month ago, I filed 2 others, and both of them were finished in 3 months. This one a year and 1 month. And that's why when people ask me, and you haven't asked me obviously here, but we get this question a lot, how long will it take? It's all over the place, and you have the option of logging into like an online website that they have, and checking. And there's a thing when you log in into your online portal that says estimated time 8 months, 9 months, and stuff. Don't get caught up in that because it's not consistent. So it doesn't necessarily mean it's actually going to happen. So I just tell clients, don't look at the timelines. It's going to frustrate you because it doesn't necessarily go by what they say. These are these wild averages and large groups that don't really go to exactly what your case is. And so be prepared for that. Just make sure you do everything right. When you apply for citizenship, it's essentially the last time they're going to review your case and look at you. And so that's why, and if there are mistakes in the process, no one's pretty much going to look at it again. Now, under President Trump, they created a denaturalization task force to kind of go back and review cases, but barring those kind of extreme kind of stuff, once you get citizenship, you're done. So this is the last step, and that's why I have to put a lot of emphasis on trying to catch any issues that exist at citizenship stage. So that's why you really want to talk with a lawyer and do a thorough consultation review. So for example, a citizenship naturalization review of consultation in my office, we're going to spend like a detailed time going through exactly everything for your life. So I can just hear stuff, review your documents, to try to spot issues. And hopefully there's no issues. Most of the time there's not. So if there are problems, we stop right there, because if you have problems with your case and you file for citizenship and they find it out, I've seen cases where people get sent to deportation, get their green card taken away, kicked out of the country, because they'll say, oh, 3 years ago, 4 years ago, there was this error that shouldn't have got your green card, and now you're going to get kicked out. So that's why we got to be really cautious in these kind of situations and make sure that we just don't mess up. Parmi asked, last question, my husband passed his question portion of the citizenship exam, but they requested our tax papers. Okay, so you really need to talk with an immigration attorney. They usually don't ask about tax papers in my cases. If they did, that means there's a worry there about some sort. So you want to talk to an attorney to review it, see why they would ask that, and get it done. And if there's issues, maybe withdraw the case. We'd have to see what's going on. Have you paid your taxes? Is it good? Are they questioning whether you have consistently lived in the United States or not? Because taxes is one way to see that. They can see where you're working, if you're lying about work or not. So, talk with a lawyer, review it, see what's going on as to why they would ask for taxes, which isn't typical. Although some lawyers always file tax papers with their naturalization filings, I don't, because I've never had to and they've never asked for it. But it's best practice to do it, but at the same time, just more paper, more chance of things getting lost or messed up. So with that, we gave it, you say give it to us, it's been over a month, no updates. I don't know, I have to see what's going on in your paperwork. It's not something I can answer, but Parmi, thank you for your question and coming on TikTok. So that's about it. So I want to thank everyone who joined. We'll catch up with y'all again next week. God bless, be safe. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.